Welcome to e-learning on Indian Evidence Act. In this session, we will learn the provisions from section 45 to 51. That is, what when opinion of third persons when relevant. It is in the relevancy of facts chapter. In chapter 2, this opinion of third person is relevant as per the provisions from section 45 to 51. You know, who is a third person? A person is a third person in a proceeding if he is not a party. He is not produced as a witness by the party, but still his evidence is taken because he is a third person to the dispute. When a civil dispute comes, in every civil dispute there are two parties, plaintiff, defendant, and the adjudicator is the court. Similarly, in a criminal case, we find prosecutor and the accused, and the court adjudicates. But a person who is not related to the case, is nowhere related to the case, he is a third party, but he gives an opinion, his evidence is taken by the court, his evidence is relied by the court, is accepted by the court as relevancy of facts by the court to adjudicate a dispute. You are aware, again at the cost of repetition, I should remind you. So evidence may be given on fact in issue or relevant facts. What is relevance? Relevance is there defined in section 3. One fact is said to be relevant if that is connected in any of the way within the provisions of relevancy of fact chapter 2. So now section 45 is the provision that comes within chapter 2, that is relevancy of facts. What is section 45? Section 45 says, what? When the court has to form an opinion, what? Upon a point of foreign law or of science or art or as to the identity of handwriting or fingering or impression. What are these? Court has to form an opinion on a point of foreign law or on science, art, identity of handwriting, finger impression, then the opinion upon that point of a person who is specially skilled in such foreign law, science or art, or in question as to identity of handwriting, the finger impression are relevant. The general rule is that the opinion of a person on a particular dispute is not relevant, but that becomes relevant when the court is required to form an opinion. On what point? On the point of foreign law. What is a foreign law? Foreign law means a law which is not in force in India, but a law which is force in a foreign country. Suppose in a contract, the Contract Act of America is to be applied. A contract had been entered somewhere in America and that is to be applied. So in such case, court has to form an opinion, what is the foreign law? Then the court is not supposed to know the foreign law. So in such case, the court will rely on the opinion of an expert, of a person who is specially skilled on that foreign law to know that law. Similarly, on a point of science means doesn't general science. Art doesn't mean general art. Science means science, you say for forensic science, scientific investigation of a crime, this medical examination of an injury, the cause of death of a disease. For that, the medical science, the help of medical science is to be taken. Suppose a ballistic expert's opinion is taken to prove whether a particular pellet had been fired from a particular gun, and from what a distance a particular firing was there. So that is also a opinion is to be taken on a point of science. Art doesn't mean fine art. Art means various things, maybe a profession, various a culture. These are it is very wide term is there. A wide interpretation is to be there. That is science or art. The court has to form an opinion. What? On a point of foreign law, science, art. Then on identification by handwriting, the handwriting court is required to give an opinion whether a particular, there is a dispute regarding the handwriting of a particular person. So court is required to adjudicate it, whether that is if suppose X has filed a suit for realization of money based on a promissory note from Y. Y says this promissory note is a forged one. It is that signature is not my signature. Then court has to form an opinion whether that is the signature of Y or not. Then who will identify? Though that identification can be made through expert. So expert simply gives his opinion. Expert has been defined a person who has been specially skilled on a particular subject. The person who has special means of knowledge to identify to give some opinion on certain point, he is an expert. So section 45 says court has to form an opinion, because court is not that is a master of everything. Court has some limited knowledge. Court cannot form opinion on every matter. Suppose regarding identification handwriting, regarding foreign law, regarding a science, art, identification of thumb impression, or identification of digital signature. So in such case, the knowledge of the court may be less to give a exact finding. In such cases, court relies on the evidence of a third party, that is an expert. Though expert is not a party to the suit. Expert is not giving evidence in favor of either of the parties, but he is a third party. What? His evidence is taken, what? To help the court to form an opinion on the point of foreign law, science, art, identification of handwriting, identification of fingerprint, or identification of digital signature, etc. Then the opinion of such third party becomes relevant because of necessity. Because a person who has much experience, who has skill on a particular subject, in a particular subject, particular field of knowledge, he should give opinion on a particular dispute regarding what are type of disputes, that is, what is a foreign law, what is a particular science, what is the identification of regarding identification of handwriting. So in such cases, the opinion of a person who has special means of knowledge on that subject is relevant. You go through the language used in this section, what it says: when the court has to form an opinion upon a point of foreign law or of science, that is on a point of science. Science doesn't mean this physical science, etc. Science means various scientific investigation of certain matter. Science or art. Art doesn't mean fine art. Art means this culture, etc., profession, art, custom, etc. Or as to identity of a handwriting, regarding to identify whether a particular handwriting or signature is of a particular person, or finger impression, whether a particular finger impression is the finger impression of that particular person. The opinion upon that point, of whom? Of a person specially skilled in such foreign law, science or art, or in question of identity of handwriting or finger impression are relevant. Then such persons are called experts. Who is an expert? A person who is specially skilled in such foreign law. A person who is specially skilled in a particular scientific, to give some scientific opinion. A particular person specially skilled in identification of handwriting, then or identification of fingerprint, his opinion are relevant, and such person is called expert. Go through the illustrations. The question is whether the death of A was caused by a poison. There is a dispute whether A's death was caused by poison. So court will depend upon the medical report, medical examination report of the doctor to form an opinion whether such death was due to poison or not. So the opinion of the experts as to symptoms produced by the poison by which A is supposed to have died are relevant. A particular person who is specially skilled to give opinion whether a particular person died due to taking of a particular poison, that becomes relevant. The question is whether A at the time of doing a certain act was by reason of unsoundness of mind incapable of knowing the nature of the act, or that he was doing what was either wrong or contrary to law. So a question comes before the court whether a particular person committed a particular act because of insanity, or he was not aware of the consequence of that act to get the general exception, to bring his case within the general exception chapter of the Indian Penal Code. In such case, the opinion of experts upon the question whether the symptoms exhibited by A commonly show unsoundness of mind, and whether such unsoundness of mind usually renders person incapable of knowing the nature of the acts which they do, or of knowing that what they do is either wrong or contrary to law, are relevant. The illustration C also provides the question is whether a certain document was written by A, another document is produced which is proved or admitted to have been written, another document, admitted document containing the admitted handwriting of the person was produced. The opinion of expert on the question whether the two documents were written by the same person or by different person are relevant. Normally a question document is examined by an expert who is who has special means of knowledge, who is specially skilled to identify handwriting. So along with the admitted handwriting of the person is taken, or a document which is admittedly in the handwriting of the person, that is compared with a disputed document. Then if the person gives an opinion, the handwriting expert gives an opinion that both the documents are written by the same person, then the court will form an opinion, here the document is in the handwriting of that particular person. So now, by now you are clear what is the provision? Section 45. It is when opinion of a third person becomes relevant. It is general rule is that in a dispute before the court, the opinion, who will give opinion? The court will give opinion. The court will adjudicate the matter. But sometimes it is difficult for the court to form an opinion on certain matters such as foreign law, science, art, identification of handwriting, finger impression, this digital signature, etc. Then in such case, the court's knowledge is limited. Court cannot give opinion, cannot give its judgment on every sphere of life or every branch of dispute or all types of dispute. But the court, ultimate adjudicator is the court. Then court will depend upon the opinion of an expert who is specially skilled. Specially skilled doesn't mean that somebody must have passed a particular examination, must have undergone a particular training. Special skill comes from the experience of a person, from the long experience of a person. Sometimes a goldsmith opinion is taken, though he has no formal education, for identification by gold. A goldsmith can identify gold because he has long experience in examining gold. That opinion, the goldsmith's opinion, is also taken, whether to find out or to form an opinion by the court whether that is a gold or not. Various experience in life. Suppose some excise officer's opinion is also taken to identify whether a particular liquid is liquor or not, because he has experience. Because of his long experience as an excise officer, he detects many excise cases. He tests on many occasions liquor in different cases. So because of his long experience, he can identify what is a liquor, what is ganja. These are things. Chemical examination report regarding ganja, whether a particular substance is ganja or opium. So for that, the chemical examination report is taken. That is a scientific opinion. So here, so you should know that is when opinion of a third person becomes relevant. Section 45 provides when the court has to form an opinion. What type of opinion? Opinion on what point? On foreign law, science. Foreign law, science. Science doesn't mean this general science, or science as taught like physics, chemistry, etc. as taught as a science subject. No. Science means a different scientific investigation, scientific determination. It's like whether a particular substance is ganja, a chemical examiner will say. Whether a particular cloth, there was a blood mark, that can be examined by serological test. That is this expert chemical examiner, that is forensic examination. By forensic examination, that can be established. So this is, court has to form an opinion, what? On point of foreign law, science, art, on handwriting, identification of handwriting, or finger impression. Then the opinion of a person specially skilled in such foreign law, science, art, identification in handwriting, or finger impression are relevant, then such persons are expert. In this context, you should know whether opinion of an expert is a substantive evidence. No, it is not a substantive, it is taken as corroborative evidence. Suppose when there is contradiction between that is fact stated by an eyewitness and opinion given by an expert, then the evidence of the eyewitness is to be believed. Eyewitness is to be believed, because only this expert opinion is taken as evidence to corroborate other evidence. This is required because court is not competent to give its opinion on all subjects, because court's knowledge is also limited. Court has limited knowledge, that is in application of law, and also this extraordinary common sense court applies while adjudicating a dispute. So because on such subjects the opinion of a third person becomes relevant. If a question comes when the opinion of a third person becomes relevant, your answer will be when the court has to form an opinion on the point of foreign law, then science, art, then identification of handwriting, finger impression, then the opinion of a person who is in specially skilled in such foreign law, art, science, identification of handwriting, etc. are relevant, and such persons are called expert. So You should refer. Now let us come to provision of section 46. Facts bearing upon opinion of experts. That means facts not otherwise relevant. Those facts are not relevant for the case, but are relevant if they support or are inconsistent with the opinion of the experts when such opinion are relevant. That means when the opinion of an expert is given, there is other fact which support the opinion or which rebut the opinion, that becomes relevant. So what it says, section 46 says, facts not otherwise relevant are relevant when if they support or inconsistent with the opinion of expert. When opinion of expert is taken in evidence as per the provisions of section 45 of the Evidence Act, then any fact which supports the opinion of expert or rebuts the opinion of expert are relevant. You go through the illustration, what it says. The question is whether A was poisoned by certain poison. It comes to a question arose before the court whether A was administered of a particular poison or not. The fact that other person who was poisoned by that poison exhibited certain symptoms which express affirm or deny to be symptoms of the poison is relevant. The fact that in other case similar poison had been administered to another person and certain symptoms which were shown to that persons were shown as the symptoms in the case, in the particular case in which it is to be adjudicated whether a particular person had been administered with that type of poison. So that supports the opinion. So that's why that becomes irrelevant. If symptoms are not such symptoms were not shown in earlier case, then that will deny that will contradict the opinion of the expert. So that's why the illustration make you clear that the question is whether A was poisoned by a certain poison. The fact that other persons who were poisoned by that poison exhibited certain symptoms which expert affirm. Expert affirm means because if that fact is shown, that supports the opinion of the expert. Or denied to be symptoms, then that if it is shown that reboots the opinion, that is contradicts, that is such opinion is thereby rebutted, that becomes relevant. The question is whether an obstruction to harbor is caused by a certain seawall. So seawall began to be obstructed at about the same time is relevant. Some seawall, what is a harbor? In a particular harbor, sometimes seawall are formed by naturally. So in a particular place, particular harbor, whether there was a seawall, on other places there were seawall, that supports the opinion of the expert. Now section 47 is another provision. What it says? When opinion as to handwriting when relevant. Opinion as to handwriting when the court has to form an opinion as to the person by whom any document was written or signed. You compare this section with the provision in section 45. Court has to form an opinion on identification of handwriting. But here section 47 says, when the court has to form an opinion that whether a particular person has written a particular document or signed a particular document, then the opinion of any person acquainted with the handwriting of the person who is acquainted with the handwriting of that person, he is not an expert within the meaning of provision of section 45. Then the opinion of a person who is acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person is a relevant fact. Here section 47 is in addition to section 45 regarding identification of handwriting of signature of a person. So this provision is there when the court has to form an opinion regarding identification of handwriting, whether a particular person handwriting or whether a particular signature is the signature of a particular person, then the opinion of any person who is acquainted with the handwriting, who is acquainted with the, such handwriting is relevant to prove whether that is the person's signature or that is the handwriting of that person. Then a person who is acquainted, he is not an expert. As per section 47, only the person who is acquainted with the handwriting of the person becomes relevant when the court has to form an opinion whether a particular document is written by a particular person or whether a particular signature is the signature of a particular person. The explanation says a person is said to be acquainted with the handwriting of another person. Who is acquainted with the handwriting of a person? A person is said to be acquainted with the handwriting of a person when he has seen that person write. If a person has seen somebody writing a document, then that person is acquainted with the handwriting of that person. Or when he has received documents purported to be written by that person in answer to documents written by himself. When a particular person has sent a letter to another person, he has received a letter from that person written by that person, then he is acquainted with that handwriting of that person. Or under his authority, or a person is doing a business, he was regularly receiving some correspondence from another person, said to be the handwriting of that person. If he gives opinion, if he gives an opinion that this is the signature, this is the handwriting of that person, that becomes relevant. So here his authority and address to that person. Or when the ordinary course of business, documents purporting to be written by that person have been habitually submitted to him. So section 47 is in addition to section 45 for identification of handwriting or signature of a particular person. Here the person who identifies, whose opinion, the person who is acquainted with the handwriting of that person, if he gives opinion, that becomes relevant. That means when the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of that person by whom they is supposed to have been written or signed, that it was or was not written or signed by that person is a relevant fact. So, who is acquainted with the handwriting? A person is acquainted with the handwriting of a person when he has seen that person writing that document or signing that document, or he has received documents purporting to be written by that person in answer to some document written by himself or under authority and addressed to that person, or when the ordinary course of business documents purported to be written by that person have been habitually submitted to him. So here you should know this person is called the person who is acquainted with the handwriting of a person. Suppose two persons are serving in a particular office. So in the regular course of business, or there is the other person was receiving some file that contained the handwriting or signature of some person. So that person is supposed to be acquainted with the handwriting of the person whose document, from whom he is receiving documents in the ordinary course of, in the usual official business. So this is called handwriting, that is person who is acquainted with the handwriting of a person. So section 47 says, when the court has to form an opinion regarding identification of handwriting or signature of a person, then the opinion of a person who is acquainted with the handwriting of that person becomes relevant. Then who is acquainted with the handwriting of a person? A person is said to be acquainted with the handwriting of a person when he has seen that person writing that document or signing that document, or he has received some document in reply to any correspondence made to him, made by him or under his authority, or in the ordinary course of business documents purporting means said to be, purporting said to be written by that person have been habitually was that documents were being submitted to him. Now illustration will make you clear. The question is whether a given letter is in the handwriting of a merchant in London, a merchant in London, whether that particular letter had been written by A. B is a merchant in Calcutta who has written letters addressed to A. B, a merchant in Calcutta, was addressing letter to B, and receiving letters purport to be written by him, by A. C is B's clerk, whose duty it was to examine and file B's correspondence. C, B's clerk, was keeping all those letters. D is B's broker, to whom B habitually submitted the letters purporting to be written by A for the purpose of advising him with these letters. The opinions of B, C, D on the question whether the letter is the handwriting of A are relevant, though neither B, C nor D ever saw writing that letter, because all were receiving those letters in the usual, in their ordinary course of business, in the business ordinary course of business, purported to be written by A merchant in London. Because B, a merchant in Calcutta, was receiving letters purported to be written by A, and he was endorsing those letters to B, C, D in his business transaction. So all are aware of the handwriting of that A. So the opinion of all such person B, C, D becomes relevant, because they are acquainted with the handwriting of a person. Who is acquainted with the handwriting of a person? That explanation provided to section 47 provides a person is said to be acquainted with the handwriting of a person who has, when he has seen that person writing that document, or if he has received any letter purported to be letter written by a person in answer to his letter, or when in the ordinary course of business, so documents purported to be written by that person have been habitually submitted to him. Now this section 47A, what is? It has been inserted in India Evidence Act by way of amendment after this coming into force of Information Technology Act 2000. What it says? When the court has to form an opinion as to the digital signature of any person, when the court has to form an opinion whether a particular signature is the digital signature of a person, the opinion of the certifying authority which has issued the digital signature certificate is relevant fact. The certified authority who is appointed under the Information Technology Act to certify regarding the digital signature of a particular person, that person's opinion is relevant. Then section 48, opinion as to existence of right or custom when relevant. This section is also that also provides what it says: when the court has to form an opinion as to the existence of a general customer right, not particular customer right. When the court has to form any opinion on any general customer right, general custom means in custom which is applicable to many persons, that is general custom. When the court has to form an opinion as to the existence of any general customer right, the opinion as to the existence of such custom or right has to form an opinion as to existence of any general custom or rights. That is custom applicable to considerable number of persons, or regarding right of considerable number of persons. The opinion as to the existence of such custom or right of person would be likely to know of its existence if it is existed are relevant. This is the opinion of a living person. But as per the section 32, clause 4, etc., that is opinion of dead persons regarding custom, etc., that becomes relevant. But here section 48 provides when the court has to form an opinion regarding existence of a general custom or general right, then the opinion of a person who was aware of such would be likely to be know of its existence if it existed, that becomes relevant. The expression general customer right includes customer right common to any considerable class of person. General custom has been defined, customer right, that is in respect of a considerable class of persons. Illustration: the right of the villagers of a particular village to use the water of a particular well is a general right within the meaning of this section. Now section 41, opinion as to usage, tenets, etc., when relevant. When the court has to form an opinion regarding the usage or tenets means any doctrine. When the court has to form any opinion regarding any usage, any tenets of any body or man or a family, the constitution and government of any religious charitable foundation. Court has to form an opinion or what? The meaning of words or terms used in particular district or by particular class of people, the opinion of person having special means of knowledge thereon are relevant facts. There are certain words it is used for a particular meaning in a particular locality. Say for example, regarding measurement, mano, this tumba, these are the words, those are used in a particular locality. The opinion of a person regarding the meaning of those words, who has special means of knowledge, having special means of knowledge thereon, is relevant. So this is section 49, when the court has to form an opinion regarding usage. Usage means any rule which is in force in a particular locality, etc. Then, or usage on a rule which is in force in a or tenets of any body of men or family, or constitution or government of any religious or charitable foundation, or meaning of any words, tenets used in particular district or particular classes of people, the opinion of person having special means of knowledge thereon are relevant. Now section 50, opinion on relationship when relevant. This is a very important provision. When the court has to form an opinion, that is also an opinion of third party. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct. Here you mark the word opinion expressed by conduct. Mere opinion is not sufficient. Opinion expressed by conduct. Conduct means that behavior. As to the existence of such relationship, what is that? Opinion accompanied by conduct as to the existence of such relationship of any person who as a member of family or otherwise has special means of knowledge on this subject is a relevant fact. What section 50? When the court has to form an opinion on relationship of one person to another, then the opinion, what? Expressed by conduct as to the existence of the relationship. The opinion expressed by conduct. Mere opinion is not sufficient. Opinion expressed by conduct as to the existence of the relationship. Regarding existence of such relationship of any person, whose opinion? As a member of family or otherwise, who has special means of knowledge on this subject, is a relevant fact. Provided that such opinion shall not be sufficient to prove a marriage in proceeding under the Indian Divorce Act, or in prosecution under section 494, 495, 497 or 498 of the Indian Penal Code. Section 50 says, when the court has to form an opinion regarding the relationship between one person, whether court has to form an opinion whether a particular person is the son of a particular person or is the adopted son of a particular person, then the opinion expressed by conduct regarding such relationship, the opinions expressed by conduct regarding as to the existence of such relationship of any person means that person must be either a family member or is having special means of knowledge, or that person has a special means to know, special means of knowledge. Suppose a purohit or a priest, family priest, he had special means of knowledge. The opinion expressed by conduct of any person regarding such relationship of a member of that family or of any person who has special means of knowledge regarding such relationship is relevant fact. But this opinion will not prove the marriage under the Indian Divorce Act or in prosecution on section 494, 495, 497 or 498 of the Indian Penal Code. Illustration. The question is whether A and B were married. The fact that they were usually received and treated by their friend as husband-wife is relevant, because here they are treating by their conduct. Opinion expressed by conduct. The question is whether A was the legitimate son of B. The fact that A was always treated as such by members of the family is relevant. So this is section 50. Section 51 says grounds of opinion when relevant. Suppose the expert has given some opinion based on certain grounds. Those grounds are also relevant whether he has given that opinion based on some grounds or not. Whenever the opinion of any living person is relevant, the grounds on which such opinion is based are also relevant. Nor of a deceased person. Whenever an opinion of a living person is relevant, the grounds basing on which he has given that opinion are relevant. This is, an expert may give an account of experiments performed by him for the purpose of forming his opinion. This is section 51. When grounds of opinion are relevant, whenever the opinion of any living person is relevant, a person is living, his opinion is relevant, then the grounds on which he gave that opinion, that becomes relevant. This is in nutshell regarding the opinion of a third person becomes relevant within the provisions of section 45 to 51 of the Evidence Act. Let us conclude. Thank you all.